Today we're going to talk about health care directives in Minnesota. My name is Gregory Singleton. I'm an estate planning and probate attorney located in Minneapolis, Minnesota. I work for Signature Law, which is an estate planning and probate law firm that serves the Twin Cities and Greater Minnesota alike. So, healthcare directives. In Minnesota, the healthcare directive is two basic documents that are put together into one. The first document is your living will, which identifies what you want to have happen to you if you become incapacitated regarding your health care. And the other document is your Health Care Proxy or your medical power of attorney, which nominates an individual to make those decisions for you. So put together, the Health Care Directive is a document that authorizes someone to make medical healthcare decisions for you if you become incapacitated based on your wants and desires and wishes. So what can go into a healthcare directive? Well, the first obvious thing is a nomination of an agent. The requirements are basically that the person has to be 18 years or older, and if they're a healthcare provider, they have to be disclosed on the health care directive. Some people want to nominate co-agents, thinking that that'll result in better decision making. I tend to tell people and advise people not to use co-agents. And the reason for this is sometimes decisions need to be made quickly, or sometimes decisions are very emotionally weighty. And it can lead any disagreement between people is going to delay a decision that needs to be made about healthcare. And if they become to a stalemate about, say, whether to pull the plug or not pull the plug, you could end up in litigation for a very long time and end up in court. So have an agent, they can talk to whomever they want, but there needs to be one decision maker. The next thing that goes into your healthcare directive is basically a statement of your values, which will be in a whole series of questions. An example of this are, what are your fears about healthcare? And an answer might be, I am most concerned that when I am in pain, I will not be given enough pain medications. Very valid fear that I've seen a number of times. You'll also include in your values section any specific instructions. You'll play the what if game. What if I am incapacitated and there's not a very likelihood chance of recovery? You could, in response, you could say, I want to be kept alive as long as possible no matter what. Or you could say, if there's not really a chance for me of making it, just pull the plug. There will be a question in there. There should be a question in there of whether your healthcare agent is allowed to be flexible based on what is in your healthcare directive, or not be flexible based on what is your healthcare directive. If a doctor comes in and says, here's an important thing, and so you have the opportunity to tell your healthcare agent to know you have to be specific or you can be flexible. Another piece of information that will be in your values section of your healthcare directive is special treatment. And specifically, I'm talking about the Minnesota Intrusive Mental Health Treatment. Now, there is a statute that says if you want to prohibit or authorize the use of either electroconvulsive therapy or neuroleptic antipsychotic medications, it has to be specific in a healthcare directive, and the specific statutory language must be included. This is a Minnesota-specific thing, but I'm sure that other states have something similar, or at least some other states have something similar. Also included in the section of specific treatments is if there is something that you absolutely don't want to have happen. Then you could say, I don't want there to be surgery on my back no matter what. Or if I'm pregnant, I want to make sure the baby lives no matter what. Another piece of information that should be in your healthcare directive is a medical history. Now, a lot of healthcare directives don't include this information, but what I ask my clients to include is basically any major surgeries, or anytime you're admitted to the hospital, just give me the facility or the city and the date. And the reason for this is if a hospital needs to find your previous medical records, they can do so with just that information. And it may not be as much of an issue with your home hospital or your home clinic, but if you're traveling and you're at a hospital you've never been to, they may need to have more information, and it sure is nice to give them that opportunity to find it. Another thing that's in your values section will be your wishes about death. What would make you comfortable as you're as you're at the end of your life? What are your religious preferences? Do you belong to a religious community? What are your wishes about your funeral? Funeral homes will respect this and will do what you wish in your funeral as long as it's reasonable. Um, if you want to have organ donation, you can include that in your healthcare directive. If you don't want to have an autopsy unless it's required by law, you can include that in your healthcare directive. And finally, you can include your body disposition, which means do you want to get buried or cremated or turned into a diamond and shot into space or whatever have you. This is what you can put in your healthcare directive, and this is where people will look for it. Another piece of information you should have in your healthcare directive is contact information. And this is contact information of the healthcare agent and essentially a statement that says, I have these documents as part of my estate plan and they can be located by contacting this individual. So if you have a will, a power of attorney, trust, whatever have you, guardianship designation, it should state it in your healthcare directive and state where you can find those documents. The final thing you need to have in your healthcare directive is a HIPAA waiver. HIPAA stands for the Health Insurance Portability and Accountability Act. And essentially, it's a 1996 law that said that if medical facilities give out your private healthcare information without a waiver, there can be monetary or even monetary fines or prison time for doing so. Now, there's an exception that says that if the hospital facility has a reasonable good faith belief that the information should be given out to someone, which you would imagine would be your healthcare agent, then they won't get in trouble. However, there's a lot of hospitals that their legal teams say, no, let's not even do that. We don't want to risk having one of our doctors or some of our nurses go to jail. So we're going to wait until there's a HIPAA waiver before we can give out that information. So this kind of busts the myth of that if you get injured and go to the hospital, then your spouse or healthcare agent will automatically have that information. They may not unless they have a healthcare waiver, and not having a HIPAA waiver may make that healthcare directive not even worth the paper it's written on. So how do we answer questions in a healthcare directive? Well, it depends on the question, of course. There are some healthcare directives that just have check marks yes or no, or 1 through 5 rate, 1 being one thing and 5 being another thing, and you pick a number in there. I don't find those healthcare directives that useful, but in my healthcare directives and a lot of other ones, you will find that people have a paragraph response to a question, such as what are your fears about healthcare? You can write in there what your fears about healthcare are. When you're doing this and filling out this type of healthcare directive, or usually it's a healthcare informational form, which will turn into your healthcare directive, be honest. This is the time to be honest about what you want. There is going to be a person that will be making decisions on your behalf about your life. When you're unable to have any input, this is your chance to have input. So be honest. If you want to be kept alive, no matter what, no matter the cost, as long as possible, put that in there. If you want to have them pull the plug, if your costs exceed your health insurance, put that in there. The other thing you want to do when answering questions is be specific. Let me give you some examples. A lot of people want to put in their healthcare directive, I just don't want to be a burden. And they just want to write that. And the problem with that is, what do they mean by a burden? Is that emotional, physical? Is that a financial burden? And let's say it's financial burden. What is too much of a financial burden? Is that $100,000? Is that to the extent of your medical, your health insurance? What does it exactly mean? So be specific about what you want. The other thing about specific that I see a lot is the question will be, if there is a very small chance of recovery, what do you want to have? And I'm incapacitated, unable to speak, unable to have my 5 senses. What do you want to have happen to me? A lot of people will say, I just want John to decide, or I want Susan to make the decision of what happens to me. Well, that kind of defeats the purpose of a healthcare directive. You're doing your healthcare directive. Well, first of all, you've already designated John or Susan to be your healthcare agent. So they're going to be making that decision. So just reiterating that they're going to make that decision doesn't help anyone. Furthermore, this is your opportunity to help them make that decision in a way that you want it to be made. So don't just say, have John make this decision for me. Give information for John to actually make the decision. Now, there are good and bad healthcare directives, and we'll start with some of the bad healthcare directives. If you're at an attorney's office and they give you a form and the form is not comprehensive, it doesn't ask a lot of questions, that's not going to be a very good healthcare directive. If the form doesn't have any questions about intrusive mental health treatment, and you're in Minnesota, of course, then it's not going to be in your healthcare directive, and it's something that you want to make sure is in there. If the healthcare form or healthcare directive only has answers like 1 through 5, it's probably not that good. And the reason I say that, answering when the question asks 1 through 5, you want to have be 1 is kept more comfortable and 5 is be lucid, for instance, and pick 1 through 5. If you pick 4, what does that mean really? You're not helping anyone by just picking a number. So it's better to have an opportunity to write in paragraph form what you specifically want. The last characteristic of a bad healthcare directive is one that doesn't include a HIPAA waiver. If you don't have a HIPAA waiver, the healthcare directive may not be worth the paper it's written on, so make sure you include it. A good healthcare directive is going to be one that makes you think. It's not going to be easy. It should not be easy to answer these questions. But you want to do it where you're taking the time to answer the questions and not leaving it to your brother or your parents or your siblings or someone to answer those questions and make those hard decisions for you. In Minnesota, we have a statutory healthcare directive, and a number of states have this. And basically, the Attorney General puts out a form that you can fill out and have notarized and witnessed and all that jazz, and you'll have a healthcare directive. On the plus side, you got something. You could do this and get it witnessed and notarized and everything, and you're good. And you'll have a basic healthcare directive, and you'll identify an agent, and you'll have something. On the bad side is these healthcare directives are usually very simplistic because they don't have someone to guide you through the questions in the form. They're not very holistic or comprehensive, so there's going to be a lot of information that's not in there. The Minnesota Statutory Healthcare Directive does not include a healthcare or a HIPAA waiver. It does not include a question about intrusive mental health treatment. So if you want to have a HIPAA waiver or something regarding intrusive mental health treatment, the statutory form is not going to be the form for you. And finally, you're still going to have to execute the form properly. You're going to have witnesses. You're going to have it notarized. If you're going through all this, you might as well go to an attorney and get a proper healthcare directive done. A healthcare directive does have to be executed in accordance with the law. I think it's Minnesota Statute 145C.03, if I'm right. If I'm wrong, then I will have a scroller at the bottom of the page. But essentially, the healthcare directive needs to be in writing. It needs to be dated when you sign it, and you need to have capacity, meaning you need to understand what the document is and understand the implications for having this document. There needs to be verification of your signature, which means having witnesses that are over the age of 18. A couple miscellaneous things about healthcare directives that you should probably know before we get into the last topic. First is healthcare directives are not the same thing as a do not resuscitate order. And the reason for that is timing. You could put do not resuscitate information in your healthcare directive, but if you go to a hospital and say you had a stroke, coming from the nursing home, you had a stroke, they're going to look for specifically a do not resuscitate order before they revive you. They are not going to look for a healthcare directive. So if it's in your healthcare directive only, then they're going to resuscitate you, read the healthcare directive, and then go, oops, my bad. And you're not going to have what you want have happen to you. The next thing to keep in mind is that in Minnesota and 41 states, there is no such thing as assisted suicide that's legal. So if you, I've seen this happen a number of times, people that say pull the plug, but make sure that they don't, what happens when you basically pull the plug is you starve and you dehydrate yourself to death. And they'll give you painkillers, so it's not an issue. If they want you to pull the plug, but they don't want you to starve and dehydrate you, then the only other option is assisted suicide. And if it's not legal in Minnesota, the Health Care Directive is not going to be legally binding. The last thing to keep in mind about healthcare directives is that willfully concealing, canceling, defacing, or obliterating a healthcare directive is a gross misdemeanor. And if it results in bodily harm to the person whose healthcare directive it is, that can be a felony. So if you are a healthcare agent and someone gives you their healthcare directive, treat it as an important document. File it away, put it in a safe somewhere that you can access it, but that it's not going to get destroyed. The last topic I want to talk about healthcare directives is what to do with a healthcare directive now that you have one. The first thing you need to do is give a copy to your healthcare agent and any successor agents. They're the ones that need this information. If they get a call from a hospital saying Bob is incapacitated, he says he has a healthcare directive and he says that you've got it, or he said that you got it, or there's a card in the wallet that says you have it, then they need to have a copy of it. It might be a good idea to try to put a copy of the healthcare directive on file with your primary care physician or with the hospital that's closest to you, because that's probably the hospital you'll go to if in the case of an emergency. Not all doctors or hospitals will keep healthcare directives on file, but quite a few of them will, so it doesn't hurt to ask. Of course, keep a copy in your home. Keep the original in your home or in a safe or in a safety deposit box. But put a card, a laminated card in your wallet. And what it needs to say is, I have a healthcare directive and a will and a trust and a power of attorney or whatever else you have. Access to these documents, or you can get access to these documents by contacting this person, and list your healthcare agent and their phone number and their email, and maybe even list a secondary agent, someone that the hospital can contact to get a hold of your healthcare directive. Because if they can't get a hold of the person and don't know that there's a healthcare directive, it doesn't do you any good. The last thing to keep in mind is that a photocopy of a healthcare directive generally is okay. If you need an original, you will have an original, but usually hospitals will acknowledge a photocopy. So that's it. That's a general overview of healthcare directives in Minnesota. If you like what you saw today, please feel free to smash that like and subscribe button below. If you have any questions, leave them in the comments and I'll try to get to them. Otherwise, until next time, this is Gregory Singleton with Signature Law.